Welcome to our webinar today. My name is James Vann, and this is Truelove. She and I practice law together, and we are so thankful that you have joined us today. So many of you are our normal participants with our webinars. We're going to be talking about preparation for mediation today. If you have any questions, as you well know, you can submit them either on the control panel of the GoToWebinar control panel on your device, or you can send it by email to webinar@vannattorneys.com. We'd love to hear from you. A lot of times, if you have a question, other people do as well, and I'm sure it would be beneficial. So a little bit more homework before we get started. We've got two webinars coming up. Another one is April 25th of this month. So make sure to mark your calendars at 3 o'clock, April 25th. You should see some information about that in the next few days. And then on May 23rd, we have another one signed up or on the calendar. So again, if there's a topic you really would like for us to cover, please let us know. We would love to hear from you so we can make sure we're hitting topics that are helpful to you. So with that, Caitlin, you ready to start?
Yes.
Well, good. All right, we're going to be talking about mediation. And, you know, mediation is something that I think we all do, whether we admit it or not, right? Whether we know it or not, right? It's negotiation, and it's something that we all participate in. So one of the things that we want to look at is what is mediation and how do we prepare for it, and then tips to consider for mediation. So those are sort of the topics we're going to be looking at. Before we get started, we've got two poll questions that we want to get your opinions on, right? That helps us all get a little bit more engaged. So Michael's going to pop up the first one for us, and it's, have you ever been part of a mediation, yes or no? So if you would, make your vote on that, and then let us know once we see that. We'll give you a few minutes to, or just a few seconds to make that determination, yes or no. And then Michael will eventually close that down for us. Folks are still voting. It's going to be easy. It's yes or no, right? So sort of like presidential candidates, you're going to have one or the other, or maybe a third, you never know. All right, so Michael's going to close that for us, and then we'll see the results. So have you ever been part of a mediation? So the answer is surprisingly no. My goodness, I'm shocked. It says 75% no, 25% yes. All right, so it's going to make the next question even more interesting. So Michael's going to pop up the next one for us. Have you found that mediation process was beneficial overall? So that's only going to really impact 25% of the voters, but we'd still love to have your opinion. So have you found the mediation process beneficial overall? So while that is up, we hope those who have participated will vote, and then we'll take a look at the results of that. All right, so it looks like it's complete. It says 50% says yes, and 50% said not applicable. So half of you say it is beneficial. So that's nice to know. Caitlin, you know, we're here to talk about mediation. What is mediation, Caitlin, and how does that work?
So mediation is constructive conversation between parties who are in conflict. This is facilitated by a neutral third party known as the mediator. Something to note is that the participants, not the mediator, control the outcome of the mediation. So if you go into mediation with a closed mind, you will come out with a lighter wallet and nothing to show for it, unfortunately. Mediation is also a great way to come to an agreement for terms that you probably couldn't get in a trial, such as if you want the other side just to leave you alone, or something that's non-monetary when it comes to relief.
So mediation, at least in North Carolina, right? If you're in Superior Court, if your attorney has filed a lawsuit for you and you're in Superior Court, in North Carolina, it's required that the case be mediated before it goes to trial, right? And a lot of times we tell our clients it's a great way to if we hadn't settled before or can't get the settlement conversation going, it's a great way to get that conversation going.
Yes.
And again, it's after you have filed a complaint or the other side's filed a complaint against your company or you. And then the answer is filed and sort of all the pleadings, sort of initial pleadings are taken care of. And then the court says, okay, y'all got to mediate this thing before you go to trial. And a lot of times they'll give you a deadline as to when it has to be mediated by and when you have to select a mediator, right? And so we're going to talk about that in just a little bit. But think about this, right? This way, a lot of times it's trying to get a mediation accomplished or get a resolution. You're trying to find common agreement on terms, right? It may be one or two or maybe five, right? Depends on the case. But the mediation is really sort of trying to find agreement on the issues that are involved. And sometimes I've been in, I know you have too, you've been in mediation, you go, this case won't ever get resolved, right? And it's amazing some of those do, right? Or you get in one, you go, that's definitely going to settle, and it doesn't, right? So it's an interesting process, and it's gotten enough experience in North Carolina now, at least in Superior Court, that I think at least most of the litigants, the attorneys and the judges, most of us probably like it in the civil side. Would you agree?
Yes.
And it's a great way to listen, right, and to learn what's going on the other side. So, Caitlin, what are some ideas about how do you select a mediator?
So you look at their background. What were they doing before they became a mediator? Were they an attorney? Were they in some other field that was legal adjacent, or in an area that is specialized in some of the causes of action that you are looking at in the complaint? Another way to look at it is to also see how many mediations have they presided over, what type of mediations have they presided over. Another thing to look at is the personality. Are they calm and cool under pressure with a good amount of empathy and understanding? Because those people tend to be able to get everybody to the table. People like people who go, I understand where you're coming from, but you need to see where the other side's coming from, versus you are absolutely wrong. That tends not to get any agreements and tends to create more conflict than resolution. Also looking at their style and approach. What is the mediator's goal in mediation? Are they looking to try and split the baby? Are they looking to see how they can follow the law, potentially, or make it seem more like what they would achieve at trial? Also, do they like to meet with all the parties in the same room together, which may not be the best idea, or have them broken out into separate rooms? I know some parties we don't ever want in the same room together. We may not even want them in the same building.
Thankfully, then it's not too often, but sometimes that's the way it is, right? In selecting the mediator, and it's really interesting to be a mediator in North Carolina, at least for the court required mediation, you have to go through a class. It's a 40-hour class. That's absolutely one of the best classes I think I've ever taken as an attorney. That makes you think about your case a little bit differently, but it's really helps you in life, because right at home, right, if you have other people that you're living with, or even at work or at church, wherever you may find yourself, right, you're dealing with others, there's going to be disagreement at times, and the mediation process helps you figure that out about how do you resolve that, right? How do you listen to the other side and hopefully find resolution. But looking for a mediator, so sometimes in North Carolina, you don't have to be an attorney to be a mediator. You can be a CPA. You can be whatever. I actually had a client who was a great business guy, and he took the class and actually served as a mediator with Superior Court cases. And I think I never hired him, unfortunately, before he decided to go do something different, but he did really well, I think, in the business cases he handled, because he knew the business side of the cases like inside and out. But we've had some, and I don't mean this negatively to my friends who are judges that are serving as mediators, because we just hired one recently in another part of the state. But sometimes judges, at least those have been on the bench for a long time, and then they retire and they start serving as a mediator. You can see sometimes it's painful for them not to say that you're right and you're wrong, right? Whomever it may be. And that's not the process for a mediator. A mediator is trying to push on both sides to make you think about your case. And that's what you want, right? You want both sides really contemplating, is my case as good as I think it is, right? Or poking you, hey, have you looked at this? Is that something, is something that you need to look at, right? We have had some experience with some mediators who, talking about style and approach, almost avoid any disagreements, right? That won't even push on the clients. Those don't settle very well, right? You need people that are going to push a little bit, and I mean respectfully, right, or make you question your case. So hopefully that makes sense. And again, if you're in this process, you're not going to be doing that. You're not going to be selecting media by yourself. Actually, your attorney probably would do that for you if it's court ordered, or if you've hired an attorney. You're not going to be doing that yourself. So what do you do, right, as a litigant, as someone that's involved in the case or the dispute? How do you resolve that, right? What do you do? Well, what we would suggest or some of the things is, how do you prepare for this? So, Caitlin, what are some topics that you've got that you think, basically looking at this, what were some things you would suggest?
So first and foremost, know your case. Know your strong points in the case, what are potential pitfalls or where it comes up short. If you have elements that are weak, or weak basis for those, know where those are and what you can do to try and bolster those, or at very least bluff.
Yeah.
And know what you're seeking with the mediation. What are you seeking? What do you want at the end of the day? If the best case scenario happened, or what are you seeking? Are you seeking money? Are you seeking some other form of relief? What is it that you're willing to take to get this done?
Yeah.
Also, review the documents that you have, potentially have a stack of them with you. Have some cliff notes that basically says how much you're willing, what's your lowball number potentially, or what you really, really want with this, and stick to it.
And a lot of times we tell our clients, we don't want to know your bottom number. I just want to know, because our goal is, if we're chasing dollars, right, which we normally do, if we're chasing dollars, we want to try to get as much as we can for you early, as early as we can. I don't really want to know the bottom dollar, and I don't even want to tell the mediator, right? Because we're pushing to get as much as we can.
But as a client, they want to know what their bottom dollar is. Don't tell us, as Jen said, keep that to yourself, but know where you are willing to take a stand and stay there.
Yeah.
Also, number 6 just goes right back into number 1. What does a successful outcome look like for you? Basically, that's what's important to you in this case.
We actually now, a couple of years ago for mediation, and the mediator was a good mediator. He's very knowledgeable in the subject matter, and we were going back and forth. Our client had a little bit more room, right, to move. Mediator comes in and says, it was a Friday afternoon, he comes in and says, all right, here's the offer that we got from the other side. And it was both sides were getting a little bit close to locking down, right? Not moving anymore. And so we had a question for the other side. Mediator goes back in the other room and then comes back at us. And y'all, I tell you, he had lost all color in his face. And we're like, what's wrong? He's like, they've left. I'm like, what do you mean they've left? Like, you don't leave a mediation until the mediator says you can leave, right? And they're like, they left. They left a note on the table and said, if you're going to accept the offer, call us. If not, we're done. They didn't tell the mediator that before he left the room. And the mediator was embarrassed. The other attorney, who thankfully we got on a better footing than we did on that day when it was over, because you don't just walk out, right? That's just not the way you handle it. But that's what they did, right? Did that turn out to be a successful mediation? Not at all. Actually went to trial and it worked out really well for our client, which I'm thankful for. But that mediation, my client looked at me, he's like, what in the world? I'm like, I don't know. I've never had this happen, right? The mediator, I I don't think had control of the client in the other room, even though the attorney respected him. The client was saying, "I'm out of here," and they left. So again, you got to know your case, right? Know the facts, and know that the good parts and the bad parts, and make sure. Sometimes even in the opening statement, right? We'll say if it's something really bad, we have to share. We're going to hit, especially if everybody knows it, right? Might as well admit it, right? I want to get it out in the open before there's a problem with it, so they don't beat you up later. But anyway, those are some tips, right, about how to prepare for mediation. So, well, let me back up. One thing that we did mention is who needs to be involved on your side, right? You got to have a decision maker.
Yes.
Someone has to be involved in the mediation, and typically it's the person that shows up at the mediation. They have to be involved and be able to make a decision for the company. And if there's other authority, right, above that person who's there, that's okay if they can reach them by phone, but you got to have somebody who has authority to settle the case. So that's just according to the rules of North Carolina.
Determine that the plaintiff's claims don't have, if they don't have any leg to stand on with their claims, you can actually potentially send a letter to the mediator before the mediation and just go through it and explain it. And if you've had discovery, you can take excerpts from depositions and send that to them and say, look, here's our stance on this. Here's why we believe that their claims have no merits. Please see page, line, and then give them the sentence and the citation for where it comes from.
You know, I was just thinking about it, Caitlin. I really thought more people would have participated in mediation. So let me back up and make sure that we explain to y'all. So what happens a lot of times in the mediation is you've hired a mediator, your attorney has, right, along with the other side. You typically agree on who the mediator is. You set a date and a time to meet, and it's either you're meeting in person or it's meeting virtually. And if you're meeting in person, you typically meet in a large conference room, right? You might meet your attorney outside of that before, just to catch up and talk and sort of, make sure everybody's on the same page. You go in, meet the mediator, meet the other side, right? And whoever's the plaintiff, well, let me back up. When you're all in the room, the mediator says, these are the rules that we will sort of go by today, right? It's how the case will be, the facts will be shared in the opening session or in the room where everybody's together. Who goes first, I guess, who can ask questions. And a lot of times it could be, sometimes no one asks questions except the mediator. Sometimes the attorneys might ask questions, right? Typically the plaintiff goes first and they sort of give a summary of their case. And then the defense goes second and they give a summary of their case. And there could be a little bit of an exchange back and forth. But it's generally not one of those where you are arguing with somebody, shouting or banging the table. Even though there's points of disagreement, right? If there are things we really want to make sure the other side hears, we'll share that, right? And I'm sure most of the opposing counsel, they do the same. But at the same time, it's not one of those where you're just slapping the other side on the table and just wearing them out. It's sort of the issues, right? And then after that, the mediator may ask questions. And then beyond that, then the parties will separate. Like the plaintiff and their attorneys will stay in one room. The defense and the defendants and their attorney go into another room. And then the mediator goes back and forth trying to find common elements of agreement on the terms, right? So that's sort of, anything else to add to that? Is that?
I think that pretty much sums it up. Have you ever experienced any hybrid mediations?
Meaning what?
Meaning where they had it partially in person and partially by.
Have you?
I have not, but I know.
Yeah.
I know with COVID and with.
I know where there have been some where some of the people didn't travel, but there were people there, but there's somebody else remote. But most of the parties, it's either you're present or you're not. And I know a lot of people still are doing remote mediations, and it's okay, right? I don't mind that but I really do. I love it when we're in the same room, because I think you can read body language a whole lot better. And people are more, I say people are more invested when they're at the table, but that's just my opinion, right? All right. So how do you prepare, right? Looking at, so what do you need to prove at court to win? And so you want to think about what the elements, when we say, what are the elements of your case, right? If it's a breach of contract, that you had a contract that was breached, that there's damages, right? Those are sort of the elements that you got to prove. And then think about, so what's the theory of your case, right? Why are you there, right? How did it get there? And sometimes you don't need a theory. Sometimes it's just a plain and simple, look, I sold a product or service and I hadn't been paid, or loaned money or whatever it may be, and I didn't get paid. Sometimes there's a theory, right? Sort of think about that. And you and your attorney will talk about that before the mediation, right? So that you sort of understand make sure that it fits, right? Make sure it makes sense. As Caitlin said earlier, you want to think about what are the weaknesses and the strengths of your case. And we had one a while back where with a client that had a computer issue happen because of some cyber issues, and it messed up their accounting for a short period of time, right? They were able to go back and piece it together, which was incredible that they could. But it gave the other side what they thought was a little ammunition to hit us, but we just addressed it early on, right? And said, we realized that, but this is how we went back and put it back together. And so we feel like these numbers are very accurate, right? So we just addressed it versus getting hit in the head with it later. And then, are there common interests that already exist with the other side? Are there things that the two sides can already agree on, right? And it's really amazing. It's almost like putting on a glove, right? You slide your fingers in. It's sort of like, we might agree on this, and we're started working on that, and you may move over here and something else. And sometimes it's just one or two issues, and other times it may be multiple, right? So hopefully that helps a little bit as far as how do you prepare for mediation, right? Looking at your case. So then we've got a few other things that we just want to look for some tips for mediation, some questions to consider in preparation, right? What is the core of the dispute, right? And why are we here? How did that dispute arise, right? And a lot of times, I mean, it may be really simple. We don't know, right? We were doing our work, and all of a sudden the other side stopped paying, or the other side stopped doing whatever they're supposed to do. This is something that I've realized the older I get, that if I can figure out what the other side wants out of the case, we might be able to figure out a way to get this resolved. A lot of times, most people don't expect totally get something for free, right? Sometimes they just don't have the money, right? Or they don't have the ability to do whatever they're supposed to do contractually. But if you can figure out what the other side wants out of it, or how they see the facts, right? At least then you're getting more of an understanding of what the dispute's about, right? What do you want to discuss at the mediation, right? Or is that something, I told Caitlin and I were talking about this the other day, just preparation for this webinar. I've been in cases before where the other side they just want an apology, right? And you think, wow, that could have been accomplished earlier, right? Who knows what it is? What does the other side want, right? What do they want to discuss? What are your limitations in making an agreement, right? Do you have some limits on what you can do or can't do, right? Are there things that you can agree to that the other side will want? And sometimes, like, I'm just to say, hey, look, if that's what they want and y'all can do it, let's do it, right? Let's just put it together.
Yes.
So again, if we can figure out what the other side wants, it really does help a lot in getting further down the road, right? And one of the things we talked about earlier is if you can ask the questions, right, what's going on? A lot of times, like even before you hire us or after you hire us and we try to get a conversation going with the other side, they may not really share what's going on. And more times, the older I get, the more I realize, I tell clients, if you listen at mediation, you will probably figure out the core of what's going on, right? If they just won't share, if they haven't said, hey, look, my biggest vendor or my biggest customer, my contract, whatever it is, has caused my problems, right? a lot of times you can listen, right, and eventually you'll hear the conversation, right, as to what really is the issue. And a lot of times, right, I say this in a funny story, right, mediation, I can't remember when it got started a number of years ago. I think I was in Winston-Salem, I think, for a mediation, and it had been around maybe 5 years or so in North Carolina. And we went into this law firm that was representing the other side. Mediator was in there. Mediator said, all right, this is how we're going to do this. Let's pretend, and he just had the attorneys. He didn't have our clients, right? Just the attorneys. He said, we're going to pretend like we've had 3 rounds of back and forth. What's your bottom dollar and what are you willing to pay? And we're like, and I'm like, we're not doing that. I'm not telling you what our bottom dollar is. He's like, well, that's how it's going to work. I'm like, no, it's not. And I don't remember if the case settled or not, but he was missing the process. And I think the process really does work a lot of times. So we want to make sure we tell you this. There are a lot of tips that we're not including in this webinar because we don't want the other side, defendants or their counsel, to hear the tips we've got, right? Realize this, we've got a bag of them left that we're not sharing because we think it's beneficial to our clients, and we would share those in a client attorney privilege conversation, not online and not something that people can watch out later. So just understand that, right? So we talked about some of those questions. Opening and joint session. So the open or the joint session is where you meet together with very early on, right? And how do you present your side of the story? So if you were going to do a breach of contract case, that just breach of contract and been paid, what would be how would you present that, you think?
On plaintiff side or on defense? Plaintiff side, I would just go through the elements of a breach of contract and go through here, the head of contract, here's contract, here's how they breached it. Our client has been damaged in X amount, and that is the amount that we are seeking. And if the client has in there about attorney's fees, great. We will ask for 15% as well.
Yeah, attorney's fees, interest, everything you can. And then, so would you like go bang the table and start? Yeah, I mean,
that's not helpful.
We had, I think Ian was in the other day, and they kept interrupting him on the joint session, on the opening session. They're like, that's not what you do, right? That's just not, you're not, maybe that feels good to the client, but it doesn't work very well, right? So you want it to be persuasive, right? Obviously, because you're trying, that's the one time that you're going to be in front of the other side, right? The attorneys and the clients on the other side. But you got to be persuasive, right? But this is not one of those where you jump up in somebody's face and start arguing your case, right? And typically in the opening session, the joint session, the attorneys are speaking mostly. Sometimes our clients will speak up, right? That they may have some information that they should share, or it comes better from them, right? Most of the time it's the attorneys back and forth. And we've had clients go, oh, I'm not saying a word. I'm just, sit back, not saying a word. That's okay, right? And then the tone, again, sort of goes back with how do you share it, right? We try to be very factual, and we have found out if you're factual, it's hard to argue with that. I mean, not to say that I don't, but it's hard to argue with it, right?
The facts speak for themselves.
Yeah. So I know what it is. So our documents used in the open session, Ian had documents he was producing or showing and I think some photos, and the other side was just going crazy. And the mediator's like, sit down and be quiet. Again, they're just putting on their case, right? It's not like they're arguing about it. It's just saying, this is the information. So hopefully that makes sense, and that's a little bit helpful to you. So some additional tips, Caitlin, what would you suggest?
As you have said before, mediation is a great time to learn what is going on with the other side. If they aren't paying because, as you've stated, they lost an account or they have run into money troubles, that's a great time to figure that out. It's also potentially a good time to get them to come to the table for a payment plan and really work on that empathy and going, I understand, I'm sorry you're in this position, but you still owe us money. So can we come to a payment plan on this? And trying to really empathize with them. I have found that honey tends to catch more flies than vinegar.
Yep.
And that tends to be the truth when it comes to mediation. Wouldn't you agree?
100%. Yep.
Also, the second point, don't give up, give the process time to work. In order to give that process time to work, you have to go into it with an open mind. It is a great way to, as I've stated before, get non-monetary relief, potentially. It's also a great way to come to an agreement together, but you have to go into it with an open mind, realizing that I may not get everything that I want, but I will hopefully get most of what I want and avoid having to go through the process of litigation and continuing to pay my attorney.
And please know there's about 5 more tips that we'd like to put on here, but we're just not going to. That would be really, really helpful to you, right? And the one thing I have learned is when you're in mediation, as you're moving, as the numbers are moving back and forth, if that's what it's a fight over, there's some ways to play, not manipulate, but to play with the numbers that you can really utilize for your benefit. So just realize that if you're in that and we're with you, we'll share that with you, right? But the process really does work. Don't rush it, right?
Yes.
So who gives the first offer? That's always, I'm not doing, so who gives the first offer?
That is typically the plaintiff, and you can go based off of what is in your complaint, or if you want to start out with a different amount, let that be known. If in your complaint it says I am seeking X amount in principal, Y amount in late fees, and accrued interest and court costs, attorney's fees as well. If you have that number where you can just give them a straight flat number for that, basically where you've added them all together, that's always a great thing, because then that's a good number to start with instead of going back and forth over what that number potentially is. And
The next point, we were talking about this earlier, about negotiation before mediation, is it good or bad, right? What always, if you can resolve a dispute or resolve a non-paid issue, right? We're like, let's do it, right? But what I have seen since COVID, seems like COVID, and I don't know why, but it just seemed like that time period. If you negotiate before you have mediation and you can't get it resolved, right? So you go to mediation. The other side typically wants you to pick back up wherever you stop in a negotiation. I'm like, no, we're not doing that. If you're owed 100,000, if we negotiated down to 75, we're not starting at 75 in mediation. We're going back to the 100 plus the attorney's fees, the interest and court costs, and everything else we can add to it, right? And I know I've gotten pushback from some mediators and some opposing counsel, but I'm like, I started saying that early on when we're in negotiation before mediation. I just want to make sure you understand, if we go to mediation, we're not starting back at this again. We're just not. So if that's your expectation, we're either not going to start at that, or you got to change your expectation, because we're not going to do that. So just have that in your head, right? And then look for alternatives and options, right? Think outside the box. And that's one of those things where I feel like, because we've had a lot of experience at this, we sort of know what tools we can pull out of the box and say, let's try this, let's try that, right? And it really does help. I think a lot of times, especially if you get down and it gets locked in place, it's really good to think outside, right? How do you get this settled without, it doesn't have to be always cookie cutter terms and conditions.
sometimes it may be that if you're owed X amount on a promissory note, that they agree to start making payments again, but that they give you a deed of trust in addition.
Right.
Sometimes it may be that if you have a deed of trust, that they agree to hand that over in lieu of foreclosure, and hopefully you get everything you want. Sometimes it may be, hey, I have this piece of equipment right here. I'm willing to give that to you as payment in full. And depending on the type of equipment, say one of those nice big Caterpillar pieces of equipment, that might be worth it.
Yeah. So we had a case just actually, I'm trying to think when we started mediation. It's been so long ago, I can't even remember. And it's a business dispute among business owners. We had to mediate, we started it last year sometime, and we met for almost a full day, I think. And thankfully, the mediator decided to, he said, do you think this would be helpful if I stayed involved and keep working with the parties? We're like, everybody said, yeah, absolutely. It worked out. We just settled the case this week. And thankfully, I don't know that we would have gotten there, but for having that mediator involved back and forth. And I'm not going to go a lot more detail because I don't want that to come back and bite us down the road, but it really was helpful. And again, it was the process, right? That's what made it work. We all, well, I can't, I'll tell you some of those tips later. I'm thankful that it has settled. We actually, one little thing unraveled this week. We're just praying that it doesn't unravel the whole thing, but I think it's going to settle. But again, trust the process. And usually, and I would say talk to your lawyers about it, right? That's the biggest help I think you can have. That way you walk in confident on what you're doing. Right?
Yes.
Well, hopefully that's been helpful. If y'all got questions, please let us know. You know how to reach us. And if you've got people on your team that you want to get the information about these webinars, please make sure you can send that to us. We'll be glad to add them to the mailing list for those. We don't sell our mailing list because no one's offered us enough money yet. Right? Yes. No, we don't sell it at all. We wouldn't sell it. But anyway, we hope this is helpful to you. Caitlin, thank you for your help.
Thank you, Jay.
It's always fun hanging out with Caitlin. And thank you all so much. And we look forward to seeing you soon. Thank you.